We are ready to start with the last panel of the conference, which is titled Simple Competition Policy for a Complex World, and I'm very happy to hand over immediately to my good colleague, Professor Pinar Akman, who is at the University of Leeds. She's also a judge at the Competition Appeals Tribunal in the UK. Pinar, you have the floor. Thanks for being with us.
Thank you, Nicola. And thank you for having me. So our panel is going to be a little bit different, perhaps, to the previous panels, mainly because we are in the unenviable position of being the final panel after 15 hours of in-depth discussions about all aspects of competition law and digital markets. So we have the challenge of finding something different and new to say. That has led us to think of perhaps taking a step back and moving away from the more detailed and technical discussions that we have been having over the last 15 hours and take a look at the issues we have been discussing perhaps from a more holistic way. And we're also going to adopt a slightly different format because, as you will have noticed from the program, there's no presenter for this panel. So in a moment, I'm going to try to say a few things in order to motivate the discussion that will follow. But the speakers will be speaking for no more than 10 minutes, and that's because we want to maximize the time we have to interact with the audience, given the brainpower in the room. So I'm going to be also strict with time. I don't know if Richard can hear us. So Richard is going to be connecting online.
I hear you.
Excellent. We can't see you. Oh, there you are. Hi, Richard. I was just saying I'm going to be a little strict with time, and that's because at least one of us has to catch a train immediately after this panel. So let me perhaps say a few remarks to motivate the discussion that will follow and to explain how I see the sort of subject matter of this particular panel. So the purpose of this session is to discuss what the scope of competition policy and law and its methods of analysis and enforcement should be in what most people would consider an increasingly complex economic reality. So I think the word complexity was mentioned probably at least 24 times in the last 15 hours, and that seems to be the main theme cutting across all of the panels over the last 2 days. And the motivation for our discussion is that, as you will know, over the last 5 to 10 years, there have been calls and movements to adopt a new set of rules and approaches to competition law and policy. And there are lots of questions these new movements raise, but two sets of questions which are particularly relevant for this panel are, first, whether we need new rules or new tools, and second, and either way, irrespective of the answer to that first question, whether these new rules and potentially new tools should be more complex or simpler than what we currently have. A particular motivation behind some of these calls for new rules and new tools is that the enforcement of competition law has been too slow in the past, so enforcement has to be sped up. And this has led to a movement of, for example, adopting simple ex-ante rules containing duties and obligations for certain market players like gatekeepers. And one question this introduction of new rules that are intended to be simple ex-ante rules, one question this raises for dynamic markets is what the pros and cons of such simple rules are in specifically dynamic settings like digital markets we have been discussing. And some of the best examples of such simple rules are perhaps those found in new ex-ante regulations such as the Digital Markets Act. And for those of you who are not so familiar with the Digital Markets Act, this is the recent EU regulation, and this regulation is supposed to apply alongside and on top of competition law with a view to engendering more competitive outcomes on digital markets through the operation of so-called self-executing blanket rules that will apply to a set of gatekeepers. And of course, this approach contrasts with the traditional antitrust approach, which adopts standards requiring a case-by-case analysis of facts and legal and economic context in which the practice takes place. Some specific examples of these simple rules, which I'm hoping that our panelists will refer to in their own remarks, include, for example, Articles 5.4 and 5.5 of the Digital Markets Act, which you can see on your screens. And as I was preparing these remarks, we had an exchange with Nicola, and I noticed that actually it was even difficult to sort of find a shorthand for what some of these simple rules were actually intended to capture. So my interpretation, and it might be different from yours, and I'd be very interested to hear that, because these don't come with these particular shorthands, but we know that they are intended to capture certain practices which have been the subject matter of various enforcement proceedings. So my interpretation is that Article 5.4 is a ban on platform most favored nation clauses, and Article 5.5 is about steering, and so that platforms enable and allow the steering of users away from their platforms. And then you have Article 6.5, which is the ban on so-called self-favoring. Now, these provisions themselves do not contain presumptions. As you can see, they're prohibitions or they're orders on gatekeepers to undertake certain practices. But we are seeing increasingly that simplicity is also sought by the introduction of presumptions. So we heard about the presumptions in the US merger guidelines yesterday, and there are some notable presumptions, which to my mind are new presumptions being introduced into EU competition law in the draft Article 102 guidelines of the European Commission. So just an example, the draft Article 102 guidelines introduce a presumption of essentially an enforcement shortcut for a wide range of practices whereby the capability to produce exclusionary effects of these practices will be presumed in the legal assessment that will be undertaken by the European Commission in a given case concerning one of these practices as a potential abuse of a dominant position. And I think the common thread among all of these rules is the elimination of complex analytical steps that would otherwise be involved in the traditional antitrust analysis. And this recent trend to move away from what they may call a rule of reason approach in the US and what we may call a case-by-case analysis in Europe denotes, I think, a willingness to simplify antitrust law in favor of something that Timur calls in the paper that was included in the reading list, the rules of the game. So in this more simplified vision of antitrust, judges and enforcers would be essentially referees, being there to call out fouls and penalties rather than trying to maximize what Timur calls fan welfare. And of course, this sort of vision of antitrust as essentially a system that sets and only sets the rules of the game has implications for the goals of antitrust and includes explicitly a desire to move away from the consumer welfare standard towards objectives such as the protection of competition, which is by definition a more process-oriented goal than an outcome-oriented goal. And Wu argues that adopting such an approach would enable antitrust to handle digital harms better because the consumer welfare standard is fixated on price, whereas the protection of competition goal is not. So in that vision of antitrust, the goal of competition law would be that of, and I quote, ultimately improving the state of play by protecting a competition process that actually rewards firms with better products, unquote. Now, of course, if you think of that expression of what the goal of antitrust should be, although this is not acknowledged by Wu in that piece, I think that approach would also translate into some variation of the consumer welfare standard in practice, because it is essentially about rewarding firms with better products, which has to mean better from the point of view of someone, and I assume that someone, the most appropriate someone in that case, would be the consumers of those products. So therefore, there's a real issue, I think, with these new visions of antitrust in terms of finding an alternative goal, which is capable of being enforced with sufficient legal certainty and which does not ultimately boil down to essentially a variation of a broadly conceived idea of consumer welfare. Now, besides this question on objectives, the recent trends raise some other questions, such as whether antitrust has become too complex for courts, and especially non-specialist courts, to handle. Another question to my mind is whether these allegedly simple rules that are supposed to facilitate speedier enforcement of the law and therefore quicker results are actually really simple at all. So you can still see the examples from the DMA there and the German Act. And in my work on the Digital Markets Act, for example, I've argued that the success of the DMA will, to a large extent, be dependent on how litigious the gatekeepers are feeling. Because even though these are meant to be more or less per se rules, which should speed up the process in comparison to competition law, and they're supposed to be self-executing, I think for many of them we can see that they will be raising similar questions to those raised in a traditional competition law analysis. And that's because if you look at the wording of these provisions, they're not necessarily that straightforward in terms of adapting these rules into applicable, essentially, rules for platforms in the DMA's case, which range from search engines to online marketplaces. And I think we are seeing already, since the recent entry into force of the DMA, that some of the gatekeepers are feeling pretty litigious, and they are litigating various aspects of this regime too. So there's a query there whether it is actually possible in a complex world to find simple rules that are genuinely simple. So the purpose of this panel is to discuss some of these questions and others related to overall the desirability and the achievability of simplicity in complex markets. So I'm now going to do a very brief introduction of the panelists in the order in which they will speak. And it's going to be a very brief introduction, so I'm only going to introduce them by their current affiliations, because otherwise Doug would definitely miss his flight. First up, we will have Richard Epstein, who is Laurence A. Tisch Professor of Law at NYU. Then we will have Keith Hylton, to my immediate right here, who is the William Fairfield Warren Distinguished Professor of Law at Boston University. Then we will have Doug Melamed, who is the Scholar in Residence at USC and a visiting fellow at Stanford University, who is sitting on my left here. And last but not least, we will have Wolfgang Kerber, who is Professor for Economic Policy at the University of Marburg. And without further ado, Richard, I would like to leave the floor to you, and I might have to stop you if you take longer than 10 minutes.
Markets as such, but I do spend a lot of my time working about complexity and how it operates in various systems. And if you're trying to talk about antitrust law, the one rule that I think you need more than any other is a rule of per se legality with respect to, by the way, the whole thing is echoing. That you need a per se rule of legality over a large number of cases rather than a series of per se rules. Ma'am, is there any way to fix the microphone? There's just a huge echo. You hear it?
Just a second, Richard. We can't hear you very well, but I'm not sure what the reason is.
Well, I mean, Well, I'll try again. At least there's no interference now. I don't like speaking to myself in a weird way. So, I mean, I think that one of the things that you want to do is to, and I, no, is that you have to be able to have a system. You you have to be able to have a system that with a fair number of per se rules on legality so that there's no government to deal with this at all. And what's happened is the way in which the European market starts to think about this on virtually everything that it does is that the first question is we're always going to have the state intervene. And then what we have to do is to find some way to make that useful. And that's the wrong way in which to do it. If you actually look at the growth of the economy and the innovation of new firms in Europe, there are no major companies that have formed underneath its various sets of rules. And in effect, I regard it as the sort of the sick man of the Ottoman Empire in terms of the way in which it constantly tries to expand itself. I recently wrote a paper that dealt with some of the stuff under the laws having to deal with the regulation of patents and their introduction in Europe, and they're just an absolute nightmare because of the broad degree of discretion that they're willing to give to panels who have no expertise in the particular kind of area. And so I think that the first question that you wanted to ask is sufficient, is complexity or simplicity a sufficient condition for getting you into social welfare? And as somebody who said, I believe in simple rules for a complex world, one of the corollaries of that position is if you have the wrong simple rule, i.e. a rule of per se illegality when there ought to be a rule of per se legality, the results are going to be absolutely disastrous because what's happened is you're going full speed in the wrong direction. So any discussion dealing with the question of simplicity has to make sure that the rules that are done do meet some kind of standard of consumer welfare, even indirectly, by which I mean not just consumer welfare, but the sum of consumer and producer welfare in a particular transaction, which is organized in such a way that it doesn't impose negative externalities on the rest of the world. Competitive situations do that by creating opportunities. Monopolistic situations do not by essentially carrying the market. So then the issue is how do you want to organize a market? And the first thing I think that's wrong with virtually everything that is done today is people want to treat innovation as though it falls into some kind of a separate category, meaning in effect that we have to have rules for innovative firms and rules for non-innovative firms. There's no such dichotomy in the real world. Every company, whether it's old or new in terms of what's going on, has some degree of innovation associated with it, and we don't know what the percentage is, and we don't want to create a dichotomy when there's a continuous distribution on that level. So what do you want to do? You want to find out ways in which you could structure a legal system so that those people who want to create innovation are free to do so, where those who want to basically specialize in mass productions of consumer goods can do it, and they can all do it within the same framework of legal forms. So what is it the way in which a liability system ought to work in this kind of world? The most essential important thing when you're trying to deal with liability, whether you're right or wrong, is that the rules have to be discontinuous and the categories have to be clear. If you don't have that situation, you're going to have an endless number of blended cases, and none of them will be able to work with the other because you can't figure out how to sort them out. So if you want to start with the design of a highway system, a complex situation, what you do is you have white lines down the middle of the road that you cannot cross, you have on and off ramps and so forth. And what the system does is it creates a rule of traffic, which essentially means that everybody can go within the rules and never collide with anybody else, so that the wrong cases are a tiny fraction of the cases, and those have to be dealt with separately. And that's exactly what you want to do when you're dealing with various kinds of businesses. And so if you start looking at the way in which traditional legal systems have worked, what happens is they always have a large number of categories, which turn out to be dichotomous in the way in which they go. One of my areas is dealing with the great commercial republic, i.e. the Republic of Rome. And I spent a lot of time dealing with Roman law. And one of the characteristic situations they have, like everybody else, is they have to work with guarantees. And what they did quite correctly was to say, here are two different categories. They're sharply distinguished. If you want to have a situation where everybody is responsible to everybody, well, you use this particular form called fido-usur. And if you want to have a situation which is quite different, namely one in which person is only liable for a pro rata share, well, you can do that with a different form for primosur. Whenever you're dealing with these forms, they have to be perfectly clear from the record. There can be no ambiguity. So if you want to come into a modern version, we have the same rule with respect to checks on the one hand as negotiable instruments and notes, because if you designate something as a check, it means that the buyer takes free of defenses against the person who issued the check. And if you have a note, it means that those defenses do it. There is no dominant solution under these cases. What people want to do is to take either one or other of these kinds of things, but the choice is theirs which to use, and then you could start to combine it with all sorts of other operations. And the secret, therefore, with respect to liability rules in virtually every situation is to have that kind of sharp discontinuity so you know whether you're in this particular game or not. My worries about the Digital Market Act is they're always going to have the wrong clear rules, which means that things are going to be disruptive because I don't see any theory of optimization that drives it. And then you have the next question about how do you do liability. And there are, of course, two forms of liability, and both of them are very complex. But essentially, if you're talking about damages, what you do is you don't need a rule which has a sharp dichotomy, since damages could come in all varieties and sizes. What you do is you need to have a continuous function so that as the harms get larger, the damages themselves can become greater in terms of the way in which you start to deal with things. And those rules work pretty well. Much harder to do this with respect to injunctive relief because the remedial side is not so clear. Everybody has said in the history of the world is you wish a judge with sound discretion to handle the question of whether an injunction is absolute or subject to condition. And there's nothing about the Digital Market Act or any other statute that's going to get you to escape that particular result. The ultimate strategy, therefore, in all of these cases is to try to avoid damages by having very clear rules for compliance so that the hard cases do not take over and dominate the particular system, which is why you design highway systems and various sorts of commercial classes, as I'm talking about, with the same kind of efficiency. And as my friend Lisa Bernstein always reminds me, morning, noon, and night, is that when you're putting a legal system together, it's not just a contract, it's a series of contracts. And that series of contracts is no stronger than the weakest link that it takes place. And so what you have to do is to make sure that all these links are strong so that the system does not break down at one particular point. And that means you have to develop rules where litigation over breaches of contract don't interfere with performance. They have to be done on the side, which is done commercially by having either fidelity bonds to make sure that the work continues even if one of the contractors is insolvent, or where you have a dispute over damages, which takes place off to the side so that the normal progression of the standard kinds of cases can work. So that's the way in which one has to work in virtually every situation to do this. Now, what happens in many places is that people don't seem to observe those kinds of rules, at which point what you do is you get liability rules that turn out to be mushy. So one of the very fancy rules associated with liability in the United States, and it has its analogs elsewhere, is a rule which says that liability is determined by the level of care that you take in using the inputs that you can generate. And if it turns out they're above a certain threshold, there's liability. If it's below it, it's not. Those rules are always suicidal because what they do is they take a continuous distribution and then ask you to find a finite point somewhere on that distribution where above it there's full liability and below it turns out that there's no liability at all. And nobody has ever been able to do that. So the way in which the tort law better works is you start taking categories, which allows you to deal with simple cases. I'm just going to give you an old-fashioned example, but it makes the point. There are lots of ways in which people can interact with one another by entering onto their property. And the person who's going to be liable is the occupier.
I'm sorry, Richard, just to let you know, we have 1 minute left, if that's okay.
1 minute? That's all I'll take.
Thank you.
What happens is the older system said there are trespassers by one rule, guests by another rule, and invitees by another rule. You know what the rules are, and you know the discontinuity. And for hundreds of years, these categories have worked very well. And the moment you abandon them, I can show you from bitter litigation experience, everything turns up to be up for grabs. So again, the basic point on all of these things is liability rules have to be discontinuous, damages rules have to be continuous. And the problem about the European system is it has such a mongrelization of everything that all you get is government intervention without government clarity. Thank you.
Thank you very much, Richard. And sorry for interrupting you. Doug has to catch a plane, so blame Doug. So Keith, could we turn to you now? Could you maybe tell us whether you think antitrust has become too complex for ordinary judges?
Okay. Thanks, Pinar. And once we hit the 10-minute point, just shut me off because I've got more here than I think I can cover in the 10 minutes. You started off mentioning a bunch of per se rules and bans and presumptions and the notion that those would somehow make antitrust enforcement simpler, and I think that's not true. I think that's a fantasy if people believe that. I mean, I think almost any statutory system is going to be, complexity will enter almost any statutory system of rules. Jeremy Bentham gave the simple example of a statute that says you can't lay hands on a priest and spends a page or two talking about the different meanings that could have, from you literally can't lay hands on the priest to someone can't arrest, a police officer can't arrest the priest. And all of these are plausible interpretations. So almost any simple rule is going to run you, that you think is simple, in a statutory system is going to run you into problems. Given the title of the panel, I thought I would just give some broad remarks on what I think is an optimal design for competition law enforcement, try to link it with some of the discussion over the past day or so. And again, there's a lot of points that people made, and so I certainly won't be able to cover all of this in the time that's allotted. So I think the first question is really one of institutional design. How do you design a system that's relatively simple? And I think there's a lot to be said for a very simplified version of the common law system. Adversaries going against each other in a court or some sort of judicial forum, and a neutral judge in between them. And that's a very simple design. The judge is by nature going to be weighing off or comparing the different interests of the other parties and trying to reach some sort of balance between their arguments, in a sense, and sort of making some balance in the welfare effects of the decision. And that's a very simple model of the common law system, and you can operate it with a very simple meta-norm. In the tort system, it's act reasonably, minimize total costs. You could describe it in a lot of different ways. And through that simple system, you can generate relatively specific and complex rules that apply to specific fact settings. And in a sense, that's the way American antitrust has evolved, because it started off with very simple rules under the Sherman Act. The Sherman Act it's basically 2 paragraphs. You can boil down the Sherman Act in the US to 2 sentences. And the whole issue was kicked over to judges to make decisions in a common law fashion that apply to specific fact settings. I think there's a lot to be said for the way the American system developed antitrust law. And so I wouldn't favor an approach that involves a lot of statutes, a lot of statutory rules, because I think it's a fantasy to think that that's somehow simplifying the matter and making things easier. Also, statutory systems generate a lot of rent-seeking, people appealing to the legislature, paying off politicians for getting the rules that they want. So a statutory system of competition law is bound to be a bad system, I think. I wouldn't have a system with a lot of regulators, because regulators supposedly enforcing ex-ante rules. That's also a system that becomes heavily taxing on businesses. I mean, I was struck by the AI panel, and if you just take a look online at the number of new regulations being proposed for generative AI, all these regulations are like barnacles on a ship that just prevent it from moving forward. And at this stage of the innovation process, it's probably better for government to stay on the sidelines and wait, see how things develop, unless there's some example of a really important harm that's impending. The other part of this is you have to have rules on evidence. And so the common law system operates with largely a preponderance rule, though sometimes the rule is biased, in favor of one party or the other, depending on the reasons for doing that. For example, if the state is going against an individual, then the state may be required to prove beyond a reasonable doubt. And there are good arguments for making the burden of proof, or the standard of proof, higher for the state. So I would distinguish between standards of proof and burdens of proof. A standard of proof decides how you determine whether someone has proven something. A burden determines who has the burden of proving something, and that's all part of the system as well. So if I talk about competition policy, what's the meta norm that I'm referring to? Well, we can talk about static and dynamic costs. We can talk about balancing the profits, or I would really like to think of it as normal rents from control of assets against the consumer surplus or consumer welfare effects. And so a system is trying to make some balance between those two. You know, a system of absolutely no intervention sort of says, okay, whatever you can make, whatever profits you make, you know, that's fine. We won't intervene. A system that completely, and of course that maximizes innovation in a sense, because no one ever has to worry about any kind of antitrust penalty under a system where there's no regulation at all. But then you have the opposite, a system which is full of per se rules that says you can't do anything. Anything you do is an antitrust violation. Anything you do that might maximize your profits or increase your profits and possibly work against the interests of consumers is a violation of the law. And of course, that minimizes static costs. On the other hand, it also minimizes the dynamic benefit from investment as well. So you have a trade-off that's there. And that trade-off, by the way, you see that in a lot of fields. You see it in IP as well. So Ron Cass and I wrote a book on the intellectual property laws, and we surveyed the intellectual property laws, and through the whole book, we're talking about balancing dynamic costs and static costs. And so, you know, if you want to see the application of that language to the intellectual property laws, take a look at our book, because that, you know, we describe the intellectual property laws in the same way. So I think IP in some ways is a classic illustration of this kind of balancing done in the common law process. And there's certain doctrines that have been developed in IP that can be described in that fashion and based on that fashion, such as the abstraction principle in patent law that is clearly a balancing of static and dynamic costs. By dynamic, I'm referring to the innovation process, incentives to innovate. Static, referring to everything, referring to the same things that people have been talking about here: consumer welfare, competition in the market instead of competition for the market. The first panel that we had yesterday, most of the talk was of a static analysis about how to improve, you know, how to minimize static costs. You know, Chris took a different approach, but that would be an example of, you know, of the static approach. Referring to efficiencies, that's largely a static analysis in modern competition law. And I said, you know, maybe a better approach is to look at replicable efficiencies rather than whether the efficiencies are passed on. We talked about capabilities, and maybe I'll say a little bit about that before we move on. So capabilities, I said it seems to me that they can be broken down into three types. You know, there's the animal spirits capabilities, technical capabilities, objective capabilities. What are the profit conditions? And in a rational competition law system, I would put more weight on the objective evidence of capabilities. What are the profit incentives for an actor to do one thing versus another? The other features, looking at animal spirits, looking at technical capabilities, well, that's a matter of evidence. Those arguments can be gamed by people. It depends on who are you going to believe when they say these things. What's the evidence they're going to bring forward? Where's the objective evidence on profit conditions and costs? That's something that I think would be more reliable in doing a capabilities analysis in competition law. And I could apply that directly to the entry problem. You know, the entry problem, you can go through the same three questions in the context of entry. Maybe the last thing I'll talk about is the merger guidelines, because I have other points. The merger guidelines, there are two parts of that. One, there's a reporting burden that came along with the merger guidelines that raises the cost of reporting by a factor of 4, and that's by the agency's own admission. So that is going to put a blanket on merger activity with small level firms. So it's raising the cost. And the other part, the actual guidelines, are discretion maximizing for the agencies. That seems to be the principle behind the new merger guidelines. And that's a problem because that simply kicks up a cloud of uncertainty around the merger guidelines. So they were originally designed, the 1968 merger guidelines. People like Oliver Williamson were thinking that we needed to provide some certainty and predictability to firms about what's going to happen. I'll stop there.
Thank you very much. Doug, you have recently published a paper which was included again in the reading list, in which I think you are arguing that there may actually be a simpler approach to antitrust if we could. I think what you do is you categorize the various micro questions that we ask in antitrust into broader but simpler, well, simpler because there aren't so many of them. You essentially reduce them into two big questions, which you think may be able to answer pretty much all of the antitrust questions that we are asking. So would you like to tell us a little bit about that approach? I can do it.
In the time available to me, I'm going to spend most of my time kind of addressing the topic that Pinar just mentioned, talking about U.S. antitrust law. I think what I'm going to say applies for the most part to EU competition law, but it would complicate exposition to try to make that explicit in my comments. It surely applies to both static and dynamic analysis. And then at the end, I'll spend a couple minutes talking about the DMA. Okay, antitrust law faces a really daunting task. It's a law of general application. It applies to almost all commercial conduct, and thus applies to a multitude of diverse and changing technologies, markets, and conduct. So over time, that complexity has led to a proliferation of substantive rules, which some have called micro-rules. They're intended to focus analysis and facilitate decision-making. Some are intended simply to simplify analysis, ignore out-of-market effects when you're doing an analysis, or using market share presumptions. Some are categorical conduct rules, predatory pricing, refusals to deal, potential competition mergers, and the like. Now, in theory, this is probably optimal. There could be a rule optimized for each of the various types of conduct and the various circumstances, and the rules could take into account not only the economics that an omniscient fact finder would focus on, but also the costs and likelihood of false positives and false negatives and error costs, therefore, and they could optimize the rule accordingly. And now, each of these micro rules addresses a defined problem. With that, I think, in mind. So, for example, if you ask, what should the law be regarding refusals to deal, you're likely to focus on short-term costs of lack of access, long-term costs of forced access, and maybe some administrability costs. Much of the conversation about antitrust law is about these rules. Antitrust lawyers and economists talk about, oh, we got to change the predatory pricing rule, we got to tinker with it this way, or we got to add a new rule, maybe a rule to deal with self-preferencing, whatever it might be. Although it's theoretically optimal to focus on these rules, I think the proliferation of micro-rules creates a lot of problems. First, what might be called specification errors. The rules don't track their intended purpose. One reason is that even the best economists sometimes get it wrong. But especially in the US, where antitrust law develops through a kind of common law-like process, most of these rules are judge-made rules. Judges are asked to adapt rules, to formulate new rules, or informed by economic propositions about which judges know little and for which they're not trained. And the result is a lot of errors and a lot of error costs, I think. Also, rules tend to take on a life of their own. And instead of being recalibrated in light of new learning or new circumstances, they endure. This is a problem Chris Yu was talking about yesterday. Second, and I think more important than specification errors, are what you might call application errors, errors in applying the rules. One kind of application error involves misunderstanding the applicable rule. The American Express case in the United States Supreme Court involving multi-sided platforms has already proved to be fertile ground for misunderstanding. Another kind of error involves selecting the wrong rule. So I suggested a minute ago that if you start the way antitrust commentators do by asking a defined problem, what should we do about refusals to deal, you have a tractable problem. But that's not where a judge starts or where a legal counselor starts. She begins with the antecedent question: what kind of conduct is this, and what rule applies to it? So, for example, prominent scholars have written in recent years that conduct that has now come to be called loyalty discounts should be treated as if it's predatory pricing, or tying, or bundled pricing, or exclusive dealing. I think it should be treated like a loyalty discount, but we'll get to that in a minute. And in terms, of course, when you're dealing with rules and the issue of what categories my conduct going to fall into, you game the system. You make some little tweaks, a little cosmetic change here and there, and then you can say, oh, this isn't a refusal to deal, and who knows what. Okay. More generally, when there are a multitude of rules or different kinds of conduct in different circumstances and a new or ambiguous problem is presented, legal actors, judges and lawyers, default to what they're trained to do: formalistic and analogical reasoning. They focus on the rules and lose sight of what antitrust law is all about. I think it's hard to read antitrust cases as a whole, there are good ones of course, without concluding that in many of them, this is true on both sides of the pond, I think, courts simply don't know what they're talking about. I think that's often because they focused on legal precedents and analogies instead of focusing on the facts. So I've recently been drawn, and tentatively been drawn, to an idea that antitrust law should clear out the underbrush and replace some or all of its micro rules with the basic principles that are actually at the core of antitrust law. I believe all U.S. antitrust law, a little more complicated in Europe, all U.S. antitrust law involves the following principles. An antitrust violation has two elements. It involves conduct that increases market power and that is not reasonably necessary to create welfare-enhancing benefits. All the micro rules, I believe, are intended as aids to implementing those two core principles of antitrust law. So my proposal is get rid of the micro rules and reduce antitrust law to those two elements. So you go into court and you say to the judge, there are two decisions you have to make. Does this conduct increase market power? And if so, is it reasonably necessary to generate welfare-enhancing benefits? And by the way, innovation and capabilities and all that would suitably come into that second question as kind of either a defense or a rebuttal, depending on which side of the Gilbert line you're on, as suggested by the Draghi report and by Rich earlier today. Okay. The beauty of this is there'll be no specification errors, right? Because the legal rule is the normative principle on which antitrust law is based. The risk concerns application errors. Notwithstanding the difficulty of the multitude of problems that the decision makers face in an antitrust context, I'm cautiously optimistic that decision makers would actually be better able to answer those two questions, which ask them to decide two factual questions, and not to decide what's the optimal rule about predatory pricing or which is the better rule for loyalty discounts. They're asking to decide two factual questions: market power, welfare benefits. And it turns out that courts, while they're not very good at devising rules based on economics that they don't understand, are actually very experienced and very good at finding facts. So maybe we'd reduce application errors. Okay, that's sort of my big idea. Let me say that notwithstanding all that, I think there's nothing wrong, at least in theory, with special rules for designated industries or even specific firms. And those rules don't have to be all ex post. They could be ex ante regulation kind of rules, in principle. And the reasons are largely the same as the reasons why, in theory, micro rules could be optimal for antitrust law. But I think we should move in this direction only very cautiously. First, category boundaries ought to be very clear and unambiguous, so we don't fight over whether you're a platform or not. Second, we have to be confident that the special rules reflect special circumstances relevant to the economic objectives of competition law and are not a product of a public choice free-for-all. And third, we have to be confident that we can change or abolish the rules when circumstances change. Otherwise, they will soon become another form of obsolete and inefficient regulation. Now, the DMA is an obvious example of sector-specific rules, and in principle and in theory might be optimal. I'm not an expert in the DMA, but let me suggest some skepticism about its wisdom. First, some of its fundamental provisions are ambiguous. Gatekeepers are defined with terms like significant impact on the internal market. I heard some discussion of that earlier today in a slightly different context. I didn't think it was unambiguous then. I don't think it's unambiguous in the DMA. More important, some of the rules seem to have serious specification errors. The rules apply to conduct without regard to market power in anything like an antitrust market, and are thus likely to prohibit competitively harmless conduct. And if we know it's competitively harmless because there's no market power, it's reasonable, I think, to have at least a weak presumption it's probably intended to achieve something efficient. Second, some of the rules, I think, are over-inclusive and unduly rigid. A flat prohibition on self-preferencing rankings, for example, will be difficult to apply. You tell me whether there's a bias in the ranking simply inferred from the fact that the related site came up ahead of another one. That's going to be an interesting examination. Second, it will inevitably block efficient means of promoting entry and product improvement, including improvements in the core platform, which might need access to technologies of the adjacent business in order to optimize an improvement in the platform. Will that be considered self-preferencing if they start talking to each other, these two businesses, before every other competing complementer is talked to? I suspect or fear it will be. And I'm almost done. And I'm afraid that rules like that will build a constituency for their preservation. And rules like this, the DMA, they don't account for factors specifically focused in innovation, in particular capabilities, R&D markets, and the issue of appropriability of innovation. So while sector-specific rules can be valuable in theory, my bias with respect to them, as with respect to more traditional antitrust micro rules, is that we're better off applying general principles to the fact of the case instead of trying to fashion and navigate a labyrinth of complex rules.
Thank you very much, Doug. So I get the feeling that simplicity may be possible, but not necessarily achievable in a very simple way. And Wolfgang, you've done a lot of work on the distinction between rules and standards from an economic perspective, and perhaps some of those insights can illuminate, when we should go for simpler rules and when we should go for more complex, I guess, standards.
Many thanks for having me. I think, can you use the slides put on? Okay, thank you so much. Yeah, okay. So what I would like to present is a US approach for economics, rules versus standards, which has been developed in law and economics, and analyzing the DMA from that perspective. I will go a bit also on draft Article 1 or 2 guidelines now in the European Union, and then I will go to the specific aspect of dynamic competition and what this means for assessment. Regarding this DMA, I have analyzed the DMA from a rules versus standard perspective published in Concurrence. Now, the rules versus standards, I think all people who have dealt with competition policy know the old US discussion about per se rules versus the rule of reason. This is very old, and they had this long-term evolution to more rule of reason, and therefore deeper economic analysis. And you also know the error cost approach with type 1, type 2 errors, and plus regulation costs as an economic way of analyzing this. But behind this is a much more general rules versus standard approach, which you can apply to any kind of law. And so very important, I think, is CAP law, but there are a number of other economists who have developed this, really about advantages and disadvantages of rules versus standards. And standards would be, for example, consumer welfare as a standard. Now, if your advantages of rules is certainly you have a high legal certainty, you know what you're allowed to do and what not. You have lower regulation costs, but perhaps you have high error costs. Vice versa, standards where you have a deeper case-specific analysis, you might have lower error costs because you can distinguish better, but you might have higher regulation costs and lower legal certainty. And the objective is from this approach, minimizing the sum of error costs plus regulation costs. And important is from a mechanical perspective, it's not clear what the conclusion is. It depends really what we are talking about. Now, this economic approach can be applied in a much more differentiated way. It's not about only per se rules on one side and a full analysis of effects on the other side. We have many intermediate solutions, and this is a really interesting thing, the intermediate solutions, because it's very clear a full analysis of effects in competition law can only be done in very few cases. Otherwise, you have to use rules. Otherwise, it would be much too expensive. And it's also not clear whether deeper analysis always leads to better decisions. This depends what our knowledge is really, whether we can analyze very well and distinguish anti-competitive and pro-competitive. And this is not so clear how good we are in that. So we have, I think, very important are these intermediate solutions, and we have this discussion also in the US about quick look rules and safe harbor rules for sorting very fast cases in unproblematic ones and in problematic ones where we have to go deeper. And we have this instrument that we're building case groups according to certain criteria, and we make then, for example, presumptions that the behavior is anti-competitive in the case groups, but rebuttal is possible, and we can have burden of proof, different rules for fine-tuning this. And the economic logic behind of all of this, what we kind of an institutional solution we have is really designing case groups on the minimize the sum of type 1 and type order costs plus regulation costs, and always for the average of the whole case group. That's the idea, not for the individual case. That's the point. Therefore, you can put economics in competition policy in two ways. One is what we all know, is that you make case-specific economic analysis. That's what usually associated with the more economic approach and what you do is on the S. And the other is putting the economics in the design of the rules and in the structure of the rules. Yeah, this is difficult enough, but this is also an economic approach, and this is what I would like to emphasize. Now, applying this to the DMA. Now, we all know the discussion about the more economic approach and with this idea of focusing always on the case-specific economic analysis of effects of behavior on consumer welfare. And we know this has not worked so well, and there's a backlash against this approach. And the Digital Market Act is a reaction to that, we know this, and therefore we have these Article 5 and 6 obligations as ex ante per se rules for a small group of gatekeepers only. No flexibility, no rebuttal, no objective justification. Yeah, simple rules, and they have to comply directly. That's what we have right now with the implementation. It's a really radical break with a more economic approach. Yeah, but you need no investigations. But you have problems with the compliance, that's exactly the point. But the rationale is, I have understood always the DMA, the rationale, it is very clear that per se rules will often produce errors, type 1 errors. Yeah? But at the same time, you have immediate compliance, and therefore you also reduce very much also type 2 errors. And the point is you are minimizing the sum of both, and you have much lower regulation costs as if you would like to do this with traditional Article 1 or 2. This is a main economic rationale for me. Whether this is right or wrong is a second question, yeah? But this is a rationale, I think. So it can have a lot of problems in design options now of the DMA. So should we have an efficiency defense, innovation defense is the one question. Yes, and you can reduce type 1 error costs, very clear, but you increase type 2 error costs, and you have a lot of regulation costs, delays. And the more important, I think, is has a DMA chosen the best set of obligations? So the obligations themselves, which obligations, how they are designed specifically. They are certainly also not simple, as we see with the implementation. So that's a problem. And what is the effect of the combination of obligations? I think it's not discussed too much, there should be much more. Yeah, if you're applying this to gatekeepers. And how to determine whether gatekeepers comply effectively with obligation? What is our approach to this? And we have here now also as an objective contestability and fairness and not consumer welfare anymore. So the traditional economic approach, what you usually do, does not fit here. Yeah, so what is the role of economic analysis? So, and so generally, what is the alternative assessment approach we have now in DMA? What is the approach? I don't see it really very clearly. Yeah? And you have also to adapt the set of obligations. I don't want to go into this. You can also compare this with paragraph 19a German competition law, only very briefly. This is a very different approach. This is not a per se prohibition rule. Nothing is prohibited directly, only the competition authority can prohibit certain kind of behaviors. Yeah? And there was discretionary scope, and there's only a strong presumption, and the firms can give objective justification. So it's a rebuttal option here. So it's very different from the DMA, and also very different from the UK approach with firm-specific codes of conduct. Yeah? So the DMA is something special here. Now, brief, I have only 2 slides, brief about the draft Article 102 guidelines. This is exactly, again, about the role of economics. We have the old priority guidance of the Commission, which emphasizes very much as the objective economic analysis of effects of consumer welfare. And now the draft 102 guidelines, very interesting. They do not look at the economics as guidance, but at the decisions of the European courts, which is a very different kind of approach. I'm not sure if this makes it simpler. The relevance of consumer welfare is very unclear as an orientation and objective. We have a great emphasis on competition on the merits, which is an old, unclear concept. Using this term as a normal competition, all of this is not clear what this means from economic perspective. This is no economic terms, what a normal competition is. But this is very much emphasized, and I've understood it that the effects of a behavior is not a decisive criterion anymore for making a behavior either exclusionary or incompatible with competition on the merits. It's not necessary. I have understood it in that way. You use more presumptions. I think this is very compatible with a rules versus standard approach. It might be helpful, but there's still the question, are these the right presumptions? Yes, they can be the wrong ones, and then it does not help. And overall, I see a problematic tendency among my legal colleagues, so I'm an economist, a tendency of legal scholars in competition law to sideline economics concepts and analysis at all, and use more directly legal concepts and principles for solving all these problems. So I'm an economist, so I do not like this. On the other hand, I also understand that we have problems with the economic approach. Yeah, and this is something we also have here in this dynamic competition initiatives, that we have with the traditional economic approach not really happy with some static concepts, only looking at prices, old concept of market power, and we would like to focus more on innovation and dynamics. And I think the problem is not using economics and not rejecting economics, but the use of a too narrow and static concept of competition. So we need better economic approach for dealing better also with these innovation aspects, and therefore bringing in strategic management and other concepts. And we need primarily also much more innovation-specific assessment concepts and also new methods for doing this. Yeah, I think innovation markets, Richard has presented this and was very pioneer in this, was a very important starting point, but much more is needed. Use of capability is one of the options now, what we're discussing here, brings this, but it also needs much more. So the question is now, does complementing the current approach, which we think is also really problematic, with additional new approach, with looking more innovation, does this make competition policy simpler? Presumably not, but we want to have at the end a good competition policy which really fits to our future economy, and therefore I think we have to go this way, and we can discuss this in the discussion what it might mean also for rules versus standards. Thank you so much.
Thank you very much, Wolfgang. I have some questions, but I'd like to open it to the floor before I ask my questions, and we have 15 minutes. Please, Richard.
So, Doug, thank you for applying Occam's razor to antitrust enforcement, boiling it down to its essential ingredients. But I would like to drill down a little bit. So who has the burden of proof on the monopoly maintenance or accretion issue and the benefits issue. And on the benefits issue, is it consumer welfare, total welfare, and would you allow out-of-market benefits?
The short answer to those questions is I don't know. Clearly the plaintiff seems to me should have the burden on the harm, the market power creation issue. Benefits is a tricky story. And the truth is, I don't think anything, I mean, U.S. antitrust law has no idea what to do when the fact finder concludes there's both harm and benefit. And fact finders miraculously rarely find both harm and benefit. One might wonder whether they have cleverly avoided the tough issue, or maybe they just, for some reason in human nature, were persuaded by the plaintiff or the defendant to buy one story or the other as to what's going on. But if you do find both, the law, some aspects of the law say, oh, well, you balance. And the plaintiff would then have the burden at that point after the benefit has been established and the balancing. But of course, no court knows how to balance because there's no algorithm for that. How do you possibly balance the price harm from a refusal to deal against the increased likelihood of future innovation protected by the refusal to deal? So there are micro rules. I think the rules about refusals to deal or predatory pricing implicitly answer that question of when do we have a benefit that's going to win, when do we have a benefit we're going to ignore. Or you could use some kind of algorithm, the so-called no economic sense test, which basically says, would the defendant have engaged in this conduct if it didn't benefit from the creation of market power? Simply because it created a better mousetrap or it lowered its costs or whatever. Could that justify the investment? I'm actually a believer in that. I think we're down to maybe one or two people in the world now who continue to think that's a good idea. But the short answer is antitrust law doesn't know how to answer it, and so I don't feel as bad about the fact that I can't answer it now as I otherwise would.
So I think it's total welfare for sure. I mean, a consumer welfare test is highly restrictive when you think about it, because in a simple, Carnot model, every single merger is harmful to consumer welfare. So you'd never let a merger take place because the welfare effect is negative in every case. So it's got to be total welfare, really, that any antitrust system, competition law system is relying on, whatever the courts say. Burden of proof, that's something that courts figure out on their own based on, the necessities of the case. I guess someone's mentioned error. We've mentioned error costs a few times, so error costs would be a way to determine the proper allocation of burdens of proof. So that, again, I think that would be my answer to your question.
Thank you. I think I'm going to collect the questions so that in order to maximize the time. So could we have your question? Christian? Is it Christian? I can't see.
Thanks a lot. I have a question for Wolfgang. We don't have a Trinco doctrine in Europe that prevent the application of Article 102 against an entity regulated by DMA. But in practice, things are, of course, a little more curious. I'm a little curious to hear about the German experience. Does regulation under Article 19A create immunity against subsequently application of Article 102?
Thank you. Fred?
I just wanted to make a comment to defend the honor of judges. Because it seems to me that the conversation clearly showed that it's not that the problem has become too complex for judges. It has become too complex for economists. And therefore, they have a very hard time explaining to courts what it is that the courts should look at or focus on. Judges deal with complex issues in many different areas, and certainly antitrust is not any more or any less complex than many other areas. So I think that we should I mean, the tonality of some of the speeches was making too much of the assumed incapacity of judges to consider complex issues. But the consensus, I mean, we're here for the last 2 days, we've been trying to build a consensus on the issue of capability theory or innovation theory. Why? Because we didn't have a consensus, so it was not obvious, and it certainly was not obvious how we could operationalize that to help the judges in their function. So I want to say this, plus the fact that talking in general about judges can be very misleading. We have different legal systems, we have different procedural systems, we have judges of different origins, and all this, of course, has an impact on how you present cases and how easy or fast can the solution be. So I think we should not also forget those other variables. But the main point was to say that the difficulty is with the economics more than with the judges.
Thank you. David, is the question or comment?
Just a quick one to the whole panel, but particularly to Doug. I mean, it's very tantalizing, but do you, in fact, even if judges are good at finding facts, someone has to interpret the facts. The court has to interpret the facts. So aren't you opening it up for a battle of the experts with different lenses, all looking at the same facts? And is that a problem?
Part of my answer, well, I'm sorry, you want to answer? Okay, yeah.
Sorry, I was just going to collect another question. I was looking at Philip, but yeah, go ahead. Okay, 2 questions then.
Okay, very quick. My question is for you, Wolfgang. You lament the lack of economic reasoning and the rise of legal reasoning, but kind of building off what Fred said, maybe this is also because economics is somewhat struggling to conceptualize some of these things. So I wanted to ask you, what directions might economics be going in next with a view to operationalizing some of these concepts that we've talked about today?
Yeah, just a comment and then a question. The comment is, I mean, let's put the DMA into one box, which is, I think, Doug's box of specific rules in a particular sector, and we can talk about that later. But there's a strong case for a good dose of humility here by lawyers, economists, and institutionalists, because none of our systems at the moment have found the absolutely perfect answer to how to deal with some different cases in different sectors. None of them. The US system struggles with the view of the judges. Our system struggles. We swing from per se rules to a more economic approach, and then we swing back again. We haven't found that sweet spot, which Wolfgang mentioned. You know, yes, we need the benefit of economic analysis, but we don't want it to complicate things. We need it to clarify concepts for lawyers, for judges, and for economists themselves. And yes, we have to respond to a certain extent to the views of all our corporations and companies. Just don't leave us in the dark. Tell us whether we're in a green zone or a red zone or a gray zone. And also, we have to take note of the fact that any competition authority has got limited resources. So there is an argument for a certain degree of upfront guidelines, perhaps some per se rules for competition policy in general, just to be able to give some aspect of deterrence to an enforcement policy and not simply enforcement itself. And finally, this is where I come to the question. Yes, there has been, because of the deficiency in analyzing the digital markets, I said to Carlos earlier on today, I would have been grateful for her presentation before I did the Microsoft decision in 2004. Maybe I could have done the whole thing in 2 months rather than 19 months. But we're in an experimental period. I'm not sure personally, and I ask the question of the panel, if there's very much difference between an approach which says we think there are sets of companies with significant market power in the German law, in the UK situation, special market status, and gatekeepers. As a concept itself, it's more or less saying we've got to look at these. Now, in my view, we're in an experimental stage. I think the approach on the US side is to say, well, we wouldn't even go there on the specific rules in the digital sector. But do you think that out of this, this experimental period where all three the European authorities, German, UK, and European, will start to do a few cases, how long will it take for the DMA rules to be relaxed?
Okay, thank you. So I think we have 5 minutes to answer all of these. Sorry? No, I think I'm going to just allow the panelists to answer, and I'm going to let Doug go first because he might have to leave. And then if we have time, then we can go back to Nicola's question.
I'm going to respond to David's question, and in so doing, I think, reply a little bit to what Fred said. And maybe I'll start with the latter. I obviously didn't make myself clear, Fred. I was not saying judges are incompetent. I was saying that judges are given a very difficult task in the U.S. of being asked to select among or to modify in the common law tradition rules that are informed by and are supposed to, in a sense, embody economic propositions when they're not trained in economics. And I said that, I think I tried to say, I think they're very good at finding facts, so let's try to turn antitrust law into a fact inquiry rather than an inquiry for the optimal economic proposition expressed as a law. Maybe that's a crazy idea, but it wasn't premised on the fact that judges are incompetent. It was just that they were being asked to play out a position. So David, yes, it would turn it into often, I think, a battle of experts. I'm not sure it would do that more in that direction than now, because you still have the battle now, and it may be that the battle now is more difficult for the fact finder to make sense of, because it's often in the context of, let me explain why the prices are really below variable cost, as opposed to going directly to the ultimate substantive question, let me explain why this pricing actually was a good thing, not a bad thing. But that's conjecture, I don't know.
Wolfgang, I think there were some specific questions for you if you would like to go next.
Yeah, first, German law 19a and Article 102 is always applicable. Yeah? Then Todd, the problems of economics. We can talk a lot about that. No, the problem I think is more that, so one is the static thing, okay, and the other thing is that I think economists have promised too much what they can do in specific cases. Yeah? We have never developed these theoretical models, were never developed for really making predictions in concrete cases. Yeah? And so I think we have a problem here, yeah. And this is also very important, and also links to what David said about humility. I think yes, yeah, we all do not know how we should deal with that. I think we have a big problem. Yeah, I'm doing competition policy since 40 years. I've never seen firms like GAFA in this period, this entirely new phenomenon, yeah, and how to deal with this and digital transformation in combination, yeah, we have a real problem, but it's very hard to deal with that, and therefore I entirely agree we have to experiment, and we have these 3 small experiments, but we have also said, I think India also has started doing something, so we have more experiments, and perhaps also the US is coming up with a very different approach with doing something which might really help us in the long term. And for me, it's very clear that DMA is only a first step. The DMA itself will not solve the problem. Yeah, but perhaps there might be an evolution, and this is exactly how we, I think, should see this as a step-by-step evolution, and we are searching with experimenting, and I think it's the only thing what we can do. Thank you so much.
Keith and Richard, would you like to respond to any of the questions?
Sure, do you want me to go first?
I don't know if Richard can... Keith, why don't you go first while we try to get Richard up?
Okay. Well, so I will defend the honor of judges. I heard Doug's answer, and it wasn't quite a full-throated defense of the honor of judges. Yeah, I think the reason the antitrust process has worked reasonably well in the U.S. over more than 100 years is because judges are making decisions based on the facts and based on the interests, the opposing interests of the parties. And there's a simple utilitarian principle that plays out in a lot of these cases where they're trying to make trade-offs and reach a sensible conclusion. And they don't have to be geniuses to do that. They have to be competent enough to make those decisions. And antitrust law, in the federal courts and the federal court judges are generally pretty good for the most part. So no, I think there's a lot to be said in favor of the U.S. antitrust system, and in a sense, it sort of developed a lot of the antitrust rules that the EU has relied on. So there's one big positive externality is it's kicked out a lot of rules that the EU has been able to take advantage of. I think it actually shows a lot of humility because the judges don't pretend to know everything. They learn about the cases and about the law with every one of these cases. So it's a system that improves, that self-regulates, it's a system that corrects its own errors over time.
Thank you. Richard, did you want to respond to any of the questions or comments?
Antitrust law has always gone in cycles. And so, for example, if you go back 50 years ago in America, had cases like Brown Shoe, where every merger was an anathema and so forth. In the current regime with people like Lena Khan, I think a systematic judge or administrative law approach has failed because she simply overreaches with respect to too many issues having to do with things like the Grail and Umina case, the Amazon case, and so forth. And so what I see, in fact, is that there's a huge amount of economic disagreement and academic agreement on just about every issue. The number of people who have to decide these cases gets larger and larger. And I just don't think that we're going to have any kind of a coherent resolution on this. Just one particular comment about Doug. I'm going to give an old Kantian maxim, and I think it applies here as well. And it says that concepts without precepts are empty. That's having a law without knowing the facts, and precepts without concepts are blind. And so if you try to have a, as it were, fact-oriented situation without knowing exactly what it is that you're trying to optimize or achieve, it's going to fail. So I really am going to go back to what I said before, and it's a very different situation. The level of economic sophistication that we had, say, in the period between 1900 and 1920 in the United States was very low. The level of judicial performance in many cases was very high. And so there's a little paradox there, which you'll have to resolve next year.
Yeah, go ahead.
I'm going to ask my question. So we heard yesterday a lot about the Draghi report. I mean, someone mentioned that. And one concept, sometimes I like to think about the things that are not said in the conference. And it struck me thinking about this, that one concept that was pretty much absent from the discussion yesterday was the concept of market power. And so the concept of market power that came out, as Lars was saying, from sort of more economic approach in the 2000s and with this very boxy way of thinking about the economy, seems to be to have much less handle on what's going on in the real world today. And so I wonder whether we can really believe, I mean, this is to Doug, right? And I really like the market power analysis, but can we really believe that we can do much with the market power construct in relation to the economy that we have today? Do we have tools that allow us to have a richer version of the market power concept and not fall back on structural analysis, which has, all the problems we know?
That's a big question. I think maybe there are economists here who can do better, or industry. No. Industry study experts who can do a better job of answering it than I. But let me suggest that at least if you think of antitrust law as U.S. antitrust law is, and Articles 101 and 102 are, as attempting to identify conduct that should be prohibited, I think a market power element is a very valuable tool, no matter, in principle, no matter how complex the industry setting might be. If you're asking a broader question, which is, well, if you're the regulator, what do you want to do about the tech platforms? Oligopoly or whatever, you might want to look at it with a broader lens.
Yes, okay.
Really have to say is what was notable is what Frederick said is right. We really don't know the answers, especially the economists don't know the answers, especially in this field. I mean, more so than any other field. And none of you sort of said something about setting up a procedure to actually try and find the answers. It was strikingly missing, I thought, from an outsider's point of view.
So one of the big topics at last year's DCI conference was whether we could create a model of provisional enforcement of antitrust, which would allow us to experiment with changes to a market without all this liability and this and that would allow us to run these sort of natural experiments where you have in a space an intervention and in the other no intervention, and then you can compare. But what would be the procedure to do that in a way that's acceptable from a legal standpoint is the big question.
It's not only that. I mean, you could look back at past cases, at what's happened, and you could have somebody who actually is investigating this outside of the realm of any particular question. What's happening in the complementarities? What's happening? Is somebody taking? It's your job, but the fact that there's nothing going on like this seems pretty striking to an outside person who doesn't think. Who's pretty up on the field and doesn't think we know very much about this part of the field. So.
I mean,
10 seconds.
Okay, so a slight I think, if I understand, I think I'm somewhat in disagreement because, I think the beauty of the process that we've had in America is that judges are groping toward answers and figuring things out. And there is a system to find answers, and that's the common law process. And actually, I think it kind of works better than I think you've suggested this already. It works better than economists sitting in a closet trying to figure out the answers themselves, because judges are dealing with real cases and with litigants with real interests in front of them and trying to balance those interests. I think that's all I would say.
Only an answer to Nicolas about market power. I think we should really think about whether the old concept of market power, which is always defined on a market, that's the economic definition, whether this is really still the suitable approach. And it's interesting that what we have now in the DMA, they speak about economic power. They don't use market power anymore. And the UK Firminal Board does not use market power and market dominance. They use different, very vague concepts, but it's something beyond that. And the same is also with 19A in German competition law. And they look at the power of the entire firm. In UK and in Germany, and in the European Union, it's gatekeeper power. It's smaller, but looking at the power of a whole firm is an entirely different concept, which we have never used. Okay, thanks.
Thank you, and if you could please join me in thanking our panelists for this fantastic discussion as usual. Thank you.